contend her testimony changed, but it was the reason she testified the way she did was because of her bias towards the DA, which gave her motive to what the state would contend is be less than honest before the court. And what put her in
based on her fighting the subpoena, why would she have fought it if she had such a bias and wanted to say these untruths?
Because she didn't want to come on national television and have to be exposed to the things that I don't know anybody who wants to testify before a court or normal trial or normal proceeding, but one what I would qualify in this high profile nature where everybody would be able to watch.
Hi guys, welcome to my Inquisitor Martyr run, Warhammer 40k. Let's see, I got all the DLC, so no worries about that. We'll start a new character.
It's because she released confidential information.
Okay.
In the DA's office.
Except I don't know who to pick. Let's see.
And I know just because it's more conversational, which I appreciate. I know I might be getting off script, so I don't want to use up all your time if you need to get through some other things.
Next, Terrence Bradley, and I believe the one thing that the state and defense counsel can agree on, that he was less than honest at times during the proceeding and during his testimony. He, when pressed or asked by Mr. Sadow why he was fired, he basically chalked it up to a dispute between partners in a business. But when pressed by Ms. Cross, it was clear that that wasn't the reason. And what I would submit to the court, what has been referenced by defense counsel as baffling as to why the state would go into such a topic area. The state, as all counsel has when appearing before the court, has a duty of candor. And when Ms. Cross knew she was going to have to cross,
Should we do a season?
She knew he lied, and she had a duty of candor to the court, in the state's opinion, to expose that.
No, we'll wait.
More importantly, it goes to his credibility, and the statements that had been represented by defense counsel that he allegedly had made in the past. So it was important to bring that to the court's attention, because when a witness is testifying, the court is assessing their credibility and determines whether to believe the veracity of the statements made by the witness.
Skip the tutorial.
That is
Yes.
determining
Okay.
telling the truth or a lie. Furthermore, he
Level 5, okay.
reluctantly, when pressed, finally admitted that he paid off the assault victim. Eventually it started with an escrow account and led to he did pay off the victim in that case. He testified over a span of 3 days, and like I referenced to the court, he must have said 15 times that he had no personal first-hand knowledge as it relates to the relationship between Ms. Willis and Mr. Wade. More importantly, when pressed by counsel, he could not pinpoint a time in which he knew that the relationship occurred. There were many instances in which he described that very well could have fallen within the time frame that was testified, and by both Ms. Willis and Mr. Wade, as it relates to the relationship beginning or transitioning into dating in March of 2022 and into the end of the relationship in August or the summer of 2023. And as I referenced to the court, the statements that Mr. Bradley made, the state would contend are inadmissible hearsay as it relates to the statements that he was pressed and asked about what Mr. Wade told him, because Mr. Wade was never confronted with those statements. And in order for impeachment to be proper, he must be confronted with the specific statements that are alleged to have been made in order to impeach him. Again, Mr. Bradley had every motive to lie. I believe the text messages are kind of clear, are very clear as it relates to his disdain towards Mr. Wade, which due to the fact that he was expelled or exiled from a thriving law practice, and it was clear.
Okay, it's cast on.
Sided with the alleged sexual assault victim, which it's clear he assaulted her due to the fact that he paid her off. And as I referenced earlier, Miss Merchant represented to the court that Mr. Bradley had personal first-hand knowledge basically of it all, of everything, and that he would be able to basically be an impeaching machine. I think Your Honor referenced him as the star witness when you were addressing the claims that were made by Ms. Cross in relations to Ms. Merchant's representations to the court. And what I would submit to the court is that all Mr. Bradley's representations as it relates to whether or when the relationship between Ms. Willis and Mr. Wade began, and whether they cohabitated, because that was a promise that was also made, that he would be able to impeach the investigators as it relates to cohabitation, was mere speculation, gossip, and innuendo. And this is, Your Honor.
The question I got, and we can correct this while we're all here together, is that Mr. Bradley directly overheard a statement from each of these individuals that they could be impeached with. Ms. Merchant, is that accurate?
Directly overheard. Which ones are we talking about specifically?
Well, essentially, that kind of seemed to be all of them. You said Allen, Mon, Young, and then the investigators, Phil Green and Ricks, could all be directly impeached by statements overheard by Mr. Bradley.
Yes.
In reference to your question, the unequivocal answer was yes. And when Your Honor is looking through the text messages, I would submit to the court that the text messages don't even say or indicate what was represented to the court in relation to the good faith basis for this motion to disqualify as it relates to the testimony of and the ability to impeach witnesses through Mr. Bradley. What's been referenced by all counsel is Mr. Bradley's assertion of absolutely as it relates to whether the relationship existed prior to Mr. Wade's hiring. And the question in itself involves speculation, because it asks, do you think it started before she hired him? And he says absolutely. He doesn't say he knows. He doesn't provide any context as to how he knows. And in these text messages and through his testimony with the court, the source of his information was unclear. What I would say to the court. Other than the one conversation that allegedly occurred between Mr. Wade and Mr. Bradley, and I would submit to the court that conversation never occurred. That would be the state's contention. And how do we know that? We know that because that conversation was not confronted, or Mr. Wade was not confronted with that conversation. And that is evidence circumstantially, and I'd even say direct, as to that conversation not existing. Because based on the representation made by defense counsel, it would be clear that that would be a conversation that would have been relayed to, because it wasn't privileged, as Your Honor found, that would have been relayed to Ms. Merchant. And if that conversation happened, you better believe that would have been a conversation that defense counsel would have confronted Mr. Wade with and against. And the reason they didn't do that was because it didn't exist. Again, you heard from Mr. John C. Floyd III, the district attorney's father. As Your Honor heard, he was a well-respected member of the legal community for over 40 years. But the importance of his testimony was to provide the court corroboration as it relates to the years leading up to the relationship that transitioned into dating between the district attorney and Mr. Wade. What he testified to is that he moved into her South Fulton home in 2019. The evidence of his moving into that home at that time was his Georgia driver's license, a government, official government document. He further testified that not only did it wasn't that just Miss Willis and himself live at the South Fulton home, but that he often would see on numerous occasions the significant other of Miss Willis that was not Mr. Wade. He referenced that that person had a nickname of Deuce, and that he kept a lot of his belongings in the garage of Miss Willis. He specifically said he kept a lot of his disc jockey equipment, is how he referred to it.
Excellent.
Before the court, he made very clear that he had never seen Mr. Wade at the South Fulton home that is owned by Miss Willis. He made clear that he lived in that home with Miss Willis and Miss Willis alone, other than her two daughters that he would occasionally visit that home until after February of 2021. But what precipitated the soon move of Miss Willis to what I would reference as safe houses for her protection was a protest that occurred before her home in February of 2021. He expressed to the court that Miss Willis moved in the spring of 2021, and due to these threats were taken very seriously. He had only seen his child 13
Inquisitor,
times.
the epidemic that spread through the relay station was just the prelude to a full-scale chaos infestation. The Void Station is in total lockdown until the decontamination teams and the Imperial Guard troops arrive. And that could take time.
I'm just going to be straight up with the court. They were trying to make Miss Willis a liar. Is how I would submit to the court, in the sense that
Do you really believe that the Magos biologist you seek is
her safety and her family safety, which included her father and her daughters, and that Mr. Floyd remaining in that home kind of rebutted all of that, made it so it wasn't true. But he testified that he stayed in the home because it was a home that she had put her blood, sweat, and tears in and was able to buy, and that he stayed in the home because there was constant officer presence. He told the court that he bought extra security equipment. He even went as far to tell the court that he slept in different rooms on different nights because he felt his safety wasn't such a concern. So I would submit to the court that line of questioning was done in an attempt to discredit Miss Willis, but failed. Would be what the state would characterize it. Then he testified about the first time that he did meet Mr. Wade, which is in 2023 here at the district attorney's office, and he talked about how he kept cash in his home and why Miss Willis kept cash in his home. And what I would, what the court should take note of is the state didn't ask Mr. Floyd about the cash in his home. That came out through the cross-examination of the defense counsel. So there was, I guess, the implication that Mr. Floyd only did so due to his preparation with the state and his hearing and seeing news articles and clips related to the testimony that had occurred prior to him. But I would support that it's telling that information came out through questions that were asked by defense counsel, which gives credibility to the statements that were made. And he further explained as to why he taught his daughter to keep cash in the home as it relates to financial independence and having a safety net. It was further testified that he had multiple safes and that he gave Miss Willis his first lockbox, her first lockbox for situations as she described when she was testifying. And what I want to make clear is during Miss Willis's testimony, it was pressed about the cash, where she kept it. Did it follow her? Where she laid her head?
If you don't mind me asking, why are you so sure this Caius Thorne could help your investigation?
Why she just had the ability to pay cash to Mr. Wade and other people and for other situations. And what the court should take note of is that there was no evidence that controverted that at all. Where was the evidence that controverted Miss Willis's claim and practice of keeping cash in her home? There was none. In fact, the only evidence it was substantiated through the testimony of her father, Mr. Floyd. Furthermore, you heard from former Governor Roy Barnes, and his testimony was significant and important because how I would phrase it, Your Honor, is it debunks.
On this point, and I think you might have had more than an opportunity to review his testimony than I had. You say on the slide that she was the first choice to lead the prosecution. Was that actually his testimony, or was his testimony that he was asked to come aboard? Did he use the words that he was asked to lead?
Yes, it would be. That's my recollection, that he was asked to lead the prosecution. He was asked to he was asked to fill the position that Mr. Wade is currently in, which is the lead prosecutor. It was said in that way as well, as it relates to the testimony of Mr. Barnes. So I think it would be very clear. My recollection is that he said lead, but what I can submit to the court, that I know he also said that he was asked to fill the position that Mr. Wade is currently filling for the state of Georgia, which is the lead
at that
prosecutor.
time as special grand jury prosecutor. Correct.
Yeah, the special, I guess, yeah, as the special prosecutor lead the investigation, which led to the ultimate prosecution that we're here before Your Honor today. He also indicated that the reason he turned that job down was because it didn't pay enough. He said he had mouths to feed at his law firm, and that he also didn't want to live the rest of his life in bodyguards, because he had lived that for the years in which he was the governor of Georgia. Furthermore, he confirmed the qualifications of Mr. Wade, which I still find quite interesting and confusing as to attacking Mr. Wade's qualifications, in that it's almost as if Mr. Roman's counsel is asking that the state put a prosecutor on the case that she sees to be more qualified to attempt to convict her client. It's an interesting argument, and it's one that
Inquisitor, I
makes
have
no sense.
completed the task you gave me.
Furthermore,
There is no
if you
trace
were to
of the
believe
Martyr anywhere
the
in the
claims and
logbooks of my ship.
allegations, as
This
it
ship is
relates to
ancient.
Ms. Willis'
Traveled
personal
everywhere
stake
in the
in the
sector,
prosecution
and
of
still
receiving of
nothing.
financial benefits in gains.
I wish
You
I
have
had the
to
treasured
believe that
logbook of
she
my
was
rogue
also
trader
dating
clan.
Roy Barnes, the
It has
former
been in
governor,
the possession of
and
my
Jay
family
Banks.
since my
In
ancestor
addition to Mr.
received the
Wade,
warrant of
if
trade.
she has this grand plan
It
scheme
has disappeared
in order
when the
to
Inquisitorial Purge destroyed the
of the
clan
prosecution of
headquarters.
this case, because that's what they're saying. Or they're saying that she telepathically or prophetically was able to know that Mr. Barnes and Mr. Banks would turn down the position, so she could then hire Mr. Wade. It's ridiculous. It's absurd, and it's desperate. It's a desperate attempt to remove a prosecutor from a case for absolutely no reason, Your Honor, other than harassment and embarrassment. This slide, and we've been through a lot of the testimony.
I should be clear there. It was not introduced in evidence that Mr. Banks turned it down. Right? How's that part of the record?
I'd ask the court to take judicial notice as has been asked.
The district attorney testified to that. I don't recall if it.
I would be frank with the court. I don't recall if Ms. Willis testified to that exact fact, but I know that Mr. Banks represented that to the court during Monday's hearing as it relates to the allegations that were made. I understand Your Honor's position as it relates to that.
Sure, we know exactly what is in the evidence and is not. Regardless, I think your point is made.
I think it's in evidence of the record as it relates to, I guess, the issues that led up to the actual hearing in this case. So I understand Your Honor's position, but it did come out during a proceeding that was prior to the actual hearing. This slide is just a chart showing kind of the testimony of both the district attorney, Ms. Willis, and Mr. Wade, as it relates to how they met, how or when Mr. Wade became the special prosecutor, when their relationship evolved into a romantic one, talking about the trips in which they took after their relationship evolved into one that became romantic, and when it ended, and again, I would submit to the court is that those facts were consistent, and the only person who contradicted that when the relationship started was Miss Yurdi. And what I would bring to the court's attention is that it was represented to the court that Miss Yurdi was a witness other than Mr. Bradley who could bring to the forefront this issue of cohabitation. And when pressed and when asked about it, Ms. Shirley had absolutely no information as it relates to this alleged cohabitation. It was false. She said she had no information. She was asked about trips. She said she had no information about the trips. Yet, she's such a good friend that Ms. Willis confirmed each year
Inquisitor,
that Mr.
our
Willis
organ readings have suddenly spiked to
continued to be in a
alarming levels.
relationship.
We've reached the center of the chaos
2020,
infestation.
2021,
Stay alert.
until their relationship ended due to her forced resignation and splintering of their friendship, Your Honor. You heard, I guess, several exhibits, obviously.
You're in the archives, Inquisitor.
Most of them
Try to find a
exhibits
cogitator
came
that can
from,
grant you
the
access to the data vault.
divorce of Mr. Wade and Miss Jocelyn Wade, contracts for legal services, trip itineraries,
This is the central
and
auditory room.
the text messages.
If this
I would
Mandos
specifically
biologist tried
reference
to send a
prior to
report
today,
to
the
us
only text
here,
messages that were
must
before
be
Your Honor
logged here.
were Defense Exhibits 26 and 27, which it's the assertion of defense counsel that what those show is that Mr. Bradley was in information or was had information as it relates to the relationship starting prior to March of 2022, and that's just false. Those text messages do not contain that. It does not pinpoint, just as Mr. Bradley couldn't, when the relationship actually started. And furthermore, you have the testimony and the evidence of the text messages that it was mere speculation. If you, as Your Honor, reviews the full chain of text messages, it is clearly Ms. Merchant and Mr. Bradley going through what I can describe as nothing else other than a mere fishing expedition between the two of them at first, because it's asked about certain members of the DA's office who would have information as it relates to specifically, for one, Ms. Young. It is asked whether she would have information, and he had no idea. He said he assumed, he was speculating. And that is the same as each person that was subpoenaed in reference in the text messages. All of that was speculation. And you know it was speculation because not a single one of them testified. That's telling.
Excellent, guys. We'll check it next time, alright? Peace.
And if it wasn't mere conjecture, each one of those
Go to the
people
main
who
menu.
were subpoenaed would have been called to testify, like District Attorney Willis was, like Mr. Wade was,
Stay tuned.
in order to be confronted and impeached by Mr. Bradley.